This is Dishin Dirt with Gary Pickren, South Carolina's only podcast dedicated to the real estate agent craft. And now, the host of Dishin Dirt, Gary Pickren.
And greetings and welcome back, everyone, to another episode of Dishin Dirt. I'm your often opinionated but rarely wrong host, Gary Pickren, coming to you from the beautiful downtown Columbia, South Carolina offices of Blair, Cato, Pickren, Castellon. This the second week of March 2025. Really cool show for you today. We're going to talk about a new topic. We have spent the last couple of weeks talking about clear cooperation, days on market, broker-to-broker compensation. Had three really incredible guests. Today I'm going to fly solo, and we're going to talk about this new association that we saw come to being after the Sitzer and Burnette case. This has been found by two national name brand real estate agents that have been at odds with the National Association of Realtors, and they have created their own company called the American Real Estate Association. So what I'm going to do today is kind of look a little bit about that, how it came to being, what kind of their positions are, and whether or not this is an association that will rival or maybe replace NAR, or is this something that is more to supplement a second association for people to join? We're going to look at the founders, their motives behind it, some of the things they're saying, and how that is going to play out in our marketplace. We're also going to talk a little bit about some other topics that have come on, but mainly that will be the main topic today. Now, before we start today, I do want to bring up a couple things that I usually do once a year. So I want to go ahead and bring these things up to make sure everybody's on the same sheet of music here. First and foremost, this show, Dishin Dirt, is reflective of the opinions of yours truly. They're often opinionated, rarely wrong opinions, by the way. I do want to reiterate that this show is not necessarily the opinions of the Real Estate Commission. They might be wise to listen to what I'm saying because, often opinionated, rarely wrong. But these are not the opinions of the Real Estate Commission. This is simply me being a real estate lawyer, putting this out for your entertainment as well as for your education. But this is not from the Real Estate Commission. I have had people going, "Oh, I love your Real Estate Commission podcast." This is not the Real Estate Commission's podcast. It has nothing to do with the Real Estate Commission. This is Blair Cato's podcast of Dishin Dirt. Secondly, one thing I have talked about a lot this year, a hill that I want to die on, is I believe broker-to-broker compensation should go away. I think it is a terrible platform for compensation in light of Sitzer Burnett. I've talked about this ad nauseum, that when you have a lawsuit that settles for $418 million, and by the time you add everybody else to the lawsuit, it comes close to $1 billion. And one of the main claims in that lawsuit is that the listing agent should not be involved in what the compensation is for the buyer's agent, if any. Yet we still have a system that is built around that compensation concept, which is the seller agrees to pay the listing agent, and then the listing agent pays a portion of that commission to the buyer's agent. I think we're setting ourselves up for a future round of lawsuits. It's not just me saying this. It's names like James Wiggins, Leo Pereira. You look at the big names in the industry, they're recognizing this. And this is why a lot of the companies are moving away from broker to broker. I want everybody to be sure you understand this. Broker to broker compensation is not illegal. It is not outlawed. It is not prohibited by the settlement. Nowhere in there does it talk about broker to broker compensation and how y'all do that compensation. Where I'm coming from is the same place a lot of the thought leaders in this industry are coming from, which is that if we continue to do broker to broker, we're not very smart. We're going to continue to just move right down to another lawsuit here in 3 years. I think it needs to go away. I think if you talk to most of the thought leaders in this industry, they believe that, and they believe it will go away at some times. But please understand, I am not telling you that you need to go to your broker and tell your broker, we can't do broker to broker compensation because Gary said so. I wish I had that power over everybody. It'd be kind of cool. But the reality is that broker to broker compensation still is a legal way to do compensation. I don't think it's the smartest way. I think you're foolish to continue to do that, but that's this lawyer's opinion. You have to decide for your company what you want to do. I think we will see. My prediction is in 12 to 24 months that it will pretty much go away on its own, but we'll continue to see how that goes. Now, the other thing I wanted to touch base on before we get in our topic is something I'm going to pull my phone up here for. Brew Pender in my office sent me this the other day. This is a Facebook post from a lawyer named Douglas Miller. And so you're saying to yourself, what do I need to know about this Douglas Miller? Who is he? Why do I care? Well, Douglas Miller, by the way, is one of the attorneys behind the Sitzer Burnett case, the $418 million case that NAR settled. Again, when you add all of the money in the settlement together, it comes close to $1 billion. So we've talked about Michael Ketchmark a lot here at this show, but the guy behind the scenes, Douglas Miller, was one of the lawyers involved in that. So what is Douglas Miller saying today? Well, he is putting it right out there, telling you face to face, right here in his Facebook post, what his intentions are. And if I'm a real estate agent, a real estate broker, an owner of a company, and I have a lawyer that just took $1 billion out of my industry telling me where his next target is, I'm pretty sure I'm going to listen to what he's going to say, and I'm going to take heed to that, because these guys, they're not going to sit here and watch Ketchmark make all this money and not figure out where the next big lawsuit is. I've talked to some of these lawyers. They are all looking for the next big lawsuit. They're looking for the next payday. Just ask Tobacco. It wasn't one case against Tobacco. It was a death by 1,000 cuts. They kept getting sued over and over again. And every time somebody would get a big hit, another lawyer would try again. So I think we're foolish as all get out if we think that this is the end. They got their pound of flesh and we're moving on. Some people may disagree with that in the industry. That's fine. But I listen to the lawyers. When the plaintiff's lawyers are saying, this is what I'm going for, I'm going to listen to them. So what is Miller saying? Things that I'm watching. This is a post that he put out in the public for everybody to see. The first thing he's watching is brokers who are advising agents to recommend using in-house services. We've talked about this a lot. I think this is foolish on behalf of the real estate brokerages. Perhaps you have a bad model. If your model includes, in order for you to stay in business, selling mortgage, title, and insurance services. You should be making money on your core service, which is real estate agent services. But what he's telling us right now is he is looking for these brokerages that are encouraging their agents to push the consumer toward in-house mortgage, in-house title, in-house insurance. Number two, brokers who are giving better compensation splits to agents who refer title and other services to in-house providers. I've talked to some team members here in South Carolina who have told me that their broker or their team leader is doing exactly this. Their compensation is directly tied to how many transactions they push for the team lead or push for the broker to their preferred services. This lawyer is looking for those cases to file a lawsuit. Number three, brokers who are giving better desk fees to agents who refer to in-house title or mortgage, essentially giving that agent awards. I've been to several of these team meetings and been to several of these brokerage meetings. And when you have an award for the person who referred the most to your in-house lender or who referred the most to your in-house title company, those are probably awards I would never want to get. I think those are going to be Exhibit A. Number four, brokers who bonus managers to capture rates for client ancillary business. So if you're a broker at one of these large brokerages and your compensation is tied to how many closings your agents refer to title or refer to a particular lender or write a certain number of home warranties, that is where he's going to be coming after. And then number five, joint ventures with realtors, and any and all of them. I love how he puts that, any and all of them. So what Mr. Miller is saying is that he believes he has a lawsuit against any real estate brokerage that has these ancillary services in which they're encouraging their agents, comping their agents differently based on this, encouraging brokers to push this service, rewarding brokers who do these services, and in general, anybody who just has these joint ventures, because he recognizes what I have been talking about for at least 5, if not 10 years, that these agreements are not good for the consumer. They're good for the owner of your brokerage, period. They're not good for you as a real estate agent. They don't do anything for you. The money doesn't filter its way to your pocket. But here, Mr. Miller's telling us he's coming for you. So if he's going to come for your brokerage, he's going to come for these team leads. And again, if I am a lawyer and I'm advising you as a client, and I got this lawyer out here telling me I'm coming after you, I think I'm going to listen to what this guy is saying. He's not the only one. I have a friend who used to do some of these joint ventures, and he doesn't do them anymore. And I asked him why he quit. And he goes, we can only get threatened so many times with a massive lawsuit before you start listening to these people and realize they're going to come after you. We also know that to be true because when you see what happened in Washington, D.C., the Attorney General for the city of Washington, D.C., brought cases against 3 of these JV type agreements. They were title companies that had signed agreements with brokerages for the brokerages to refer business to them. They set up a title company together, and half the money went back to the brokerage. And what the Attorney General said was this was a referral scheme. Essentially, all the brokerage did was push the client to the title company. The title company did all the work, had all the liability, had all the knowledge, and at the end of the day, they kicked back a fee to the title company. So how many of you as real estate agents are working for a company that is doing that or has done that? Well, in Washington, D.C., that wound up being a $6.2 million settlement with 3 of those companies. So when people tell me, oh, well, we're covered, we don't have to worry about it, we got a joint venture, we have the best lawyers in Washington, D.C., best lawyers in New York, look at them, whatever, I laugh at that. I represented a client one time where they were asking to do a joint venture. And when the lender kept saying, we've had the best lawyers and the best people in Washington, D.C., on Capitol Hill and Wall Street looking at these things, and this is perfectly legal, my response was, well, let's put an indemnification clause in the contract. They're like, what are you talking about? I said, well, if you're so certain that you are right and that my client has absolutely nothing to worry about, and there's no way he's going to get sued because your lawyers are the smartest lawyers in the world, put your money where your mouth is and put an indemnification clause in here that says, if you're wrong, you will pay their fines, you'll pay their attorney fees, you'll pay any losses they have. And they're like, well, we can't do that. Well, that was the end of the conversation, because what that tells us is they know that they can't make those comments, that these things are perfectly legal. So go ahead and continue to do these stupid little agreements with mortgage, with attorneys, and keep doing this. And I guess I will read about Mr. Douglas Miller filing a lawsuit against you very shortly. And that would concern me, because Mr. Miller has the funds to bring the lawsuit now. Remember, these lawsuits are very expensive to bring. Well, he's funded himself with money from the Realtors Association, so it shouldn't be very hard for him to bring the case. Now, let's talk about the American Real Estate Association. What is it? Where did it come from? What's it about? Well, as I mentioned earlier, AREA, as it likes to call themselves, AREA, AREA, it came as a direct result of these lawsuits that were pending Sitzer Burnett. And the company was essentially founded by 2 big name real estate agents, Jason Haber being one, Mauricio Umansky being the other. So the question is AREA a threat to NAR? And my short answer to that would be no, it's not. It is not a threat to NAR. It may cause some headaches to NAR. It may be a bump in the road, but I do not believe that AREA is going to overtake NAR and become the industry standard. I don't think they even believe that. I've mentioned multiple times that there are some troubles ahead for NAR. They've had some troubles in the past. The sexual harassment case that we've talked about has some disturbing facts involved in it. The spending has been very bad. There's a lot of things. The case management was not the best. I actually did a podcast, 10 Ways NAR Could Suck Less. But I believe the ship is being righted now, because what we need over there is not another association that dilutes the power of NAR. What we actually need is a stronger NAR, because NAR does all the lobbying for you to make sure that you remain as an independent contractor and not as an employee, which would result in half of you, if not 70% of you, being fired, because who's going to pay you minimum wage? Particularly when 71% of real estate agents didn't even do a closing last year. The changes that I'm hearing from the people in the industry, they're very happy about, is Nakia Wright. She is the new CEO of the Realtor Association. I'm hoping I can get her on Dishin Dirt at some point, but she has a reputation of coming in and fixing things. She tears them apart, puts them back together, and fixes them. And so I believe what we're seeing already is a lot of positivity around her leadership at the helm. And so I'm hopeful that she'll have that. I understand the president, Mr. Sears, also has that same kind of leadership vibe to him. And so perhaps the answer here is stronger leadership at NAR, people really paying attention to what's going on instead of having AREA or another type of association. Now, what AREA promotes for themselves is that they allow their agents to set their own commission rates and will not require any cooperation between buyers and sellers. My question or response to that is, so what? NAR, since its beginning, has never set a commission rate. That is not what NAR does. They do not set your commission rates. That was one of the things that was alleged in the lawsuit that was absolutely false. NAR is not in the business of setting commission rates, hasn't and will not be involved. In fact, now, if you go to a Realtor Association meeting, they are so anti any discussion of commission rates, you're not even allowed to use numbers. You can't even use bananas, like 2 bananas, 4 bananas. We have to use X and Y. There is no discussion of any commission rate. Additionally, when they talk about there's no requirement of cooperation between agents, buyers agents, and sellers agents, I assume what they're talking about is cooperation in terms of commission. Because under state law, and every state has some type of real estate agent code, there's going to be a requirement of cooperation within those statutes. It may not have the specific words, you must cooperate with the other agent, but if you look at the penumbra of the statute, the language in there, and see what all it talks about, you do have requirements that require you to cooperate on the other with the other side, whether it's in presenting offers or negotiating repairs. All of these duties and so forth are in there. So I don't see that what they tout as being some big, wonderful difference in NAR is any difference at all. What I do find interesting is that when one of the owners, this Jason Haber, who works at Compass Broker in New York City, and I do also want to remind everybody, I'm brand agnostic. I don't have a favorite of most hated. I don't really care. I just look at what everybody's doing and make comment on it. But this Haber and Refkin, the guy who owns Compass, they tend to be, for me at least, on the wrong side of most of these issues, whether it's days on market, whether a house has been pulled off the market and put back on the market, clear cooperation, things like that. It seems that they're on the wrong side of almost all of these issues. And it seems to be one driving factor, which they never want to admit, which is they want to get both sides of the transaction so they can make more money. They continue to talk in circles about customer choice and things like that, because those are the buzzwords that everybody wants to hear. Well, as a customer, I want more choice. But the reality of it is it's not about giving the customer more choice. It's about them making more money, because when they explain the choice that the consumers actually get ready to make and how it's adversarial to that consumer, most of them don't want to make that choice after all. But when you look at that and you look at Mauricio Umansky, what his positions are and how he has this private multiple listing service, and understand really what their motives are behind this, it kind of makes this whole AREA association kind of not very appealing to me. They asked Jason, they being Inman News, asked Jason what he thought the biggest threat facing the industry was right now. And this will surprise you. He said, what's constantly on my mind is trust with the consumer. What really troubles me is that when you look at public opinion polls, the real estate agent on that list is generally under the used car salesman. I think that's a crime. That was a quote that he gave to Inman News. I find that to be interesting in 2 points. First of all, I don't think it's a bad thing for you. Actually, I think it's a good thing. As a real estate lawyer, I know lawyers are ranked even below real estate agents. The three most distrusted industries are real estate agents, car salesmen, and lawyers. Well, I'm two of those. Okay, so doubly dishonest, right? To me, it doesn't mean anything, because what it tells me is that in order to overcome that barrier, that barrier is so low, I barely even have to make a step to get over it. All I have to do is show you a modicum of honesty and trustworthiness. And now all of a sudden, oh, he's the trustworthy lawyer. He's a trustworthy real estate agent. It doesn't take a whole lot to show that level of trust. One of the easiest ways to show that level of trust and honesty is in your explanation of agency, doing it when the conversation turns substantive and not when you're writing a contract. Do it when it's required by law, letting them know that this is required by law. And I'm going to follow the law, even though this is an uncomfortable conversation that nobody wants to really have this early. But I'm showing you, I'm demonstrating to you that I am a trustworthy real estate agent. If you are a nurse, which is the most trusted profession in the country, more than even the doctors, in order to show that you're a trustworthy nurse, better than the other nurse, you would truly have to differentiate yourself by going so far above and beyond everybody else. You'd almost have to be a priest to get that done. I mean, it's absolutely insane, the level of that bar that you would have to cross. So the low bar doesn't really affect me at all, and shouldn't affect you as a real estate lawyer. Who cares that they think your profession is the most untrustworthy? You show any level of trustworthiness and you're going to be the greatest real estate agent. But I also find it interesting that when you look at Jason Haber and he's talking about the trust, he comes from the very company that wants to get rid of clear cooperation, and they try to spin it as customer choice. When the reality of it is, we know it has nothing to do with customer choice and has everything to do with they want to get both sides of the deal. Because we know that when consumers try to sell their properties off the multiple listing service as a pocket listing or whatever, they're going to make substantially less money. And so when they say that the consumer wants this choice, nobody's really educating the consumer on what that truly means. So it's really not about choice, because nobody wants to educate the consumer what it means. I just want to get both sides of the listing. And when you think about that, real estate agents, as Leo said, always list their houses for sale on the multiple listing. They don't list them as pocket listings. They trying to get the most money by putting it on the MLS. So if a real estate agent wouldn't sell it as a pocket listing, why would they ask their client unless they're trying to get both sides? So when he's talking about honesty and trustworthiness and why people don't trust real estate agents, well, this is a prime example. You're trying to spin clear cooperation and giving it as a consumer choice issue, when the reality of it is the truth behind it is you and your company just want to get both sides of the transaction. So I don't believe anything that he says in terms of trustworthiness. Umansky's another one of the guys that all he talks about is this private multiple listing service. Well, what is his motive behind that? He controls who's a member of the multiple listing service, and it gives him a better opportunity to limit competition and gives him a great opportunity to get both sides. So I don't really trust this whole side of trust. And so if I don't even trust the guys who are out here touting trust as one of the big problems as real estate agents, why would I trust their organization to do what is in the best interest of real estate agents? They're on the wrong side of this, and I don't think that's where they need to be. Now, to be fair to him, I did read a new article by him being Jason, and the headline really pissed me off. And then I did a little diving into the article and realized that, okay, it's not really what the article says. It's more like clickbait. But what Jason was saying is that our industry deserves better and fewer real estate agents. That was the title of the article. And to me, that was a stupid and terrible statement. We don't deserve fewer agents. I don't trust him or Umansky to be the one who decides who's worthy to be in this industry. We see what Umansky's trying to do with the private multiple listing. He only wants these $1 million listing type agents, and he wants to keep the rest of you out from being able to get in there. So I don't find that that is necessarily the best course. What I can get behind when you really look at the article and what he's talking about is that it's really not the number of agents, it's how good the agents are. And when he said we need to raise the standards, I can agree with him on that. He said he's licensed in 2 states. He just took the New York exam, and he goes, it was remarkably lightweight. I don't think the licensing standards are high enough, and I think that would be a good place to start. But he blames NAR, saying it's NAR because they benefit by having lots of agents. Well, I can tell you as a South Carolina Real Estate Commissioner, that is not true. NAR has no saying in what South Carolina does in terms of licensure requirements. They don't come and set them at NAR. The state of South Carolina does it. And the Real Estate Commission doesn't do it. We set out suggestions. We send that up to the State House, and they decided at the Columbia State House. They're the ones who make the decision. We asked for more. For example, we wanted 14 to 18 hours of continual education. The House of Representatives fought that and knocked it down to 10 hours. So you can want a higher bar of entry. You can want more education. You can want more required training, but it's all ultimately up to the State House to decide what they're going to put in the statute. It has nothing to do with NAR. Training, education, and holding agents accountable are the key to having better real estate agents, not necessarily a higher bar. Perhaps we do need the higher bar. I'm not saying we don't, but what would that higher bar look like? It, to me, should be more education on the front end. We are trying at the Real Estate Commission to really drill down and see which companies are providing quality services for students to provide the information they need so they can be successful in taking the test and successful as real estate agents. But ultimately, the marketplace will decide whether those companies stay in business or not. But requiring more education, but also agents holding other agents accountable, whether it's through the grievance process at the Realtors Association or the grievance process for the Real Estate Commission. All of that has to happen in order for real estate agents to be better agents. So I don't think fewer agents the problem. I certainly do not believe that NAR has any say in that. It truly is about more education and holding people accountable. So if you're going to be AREA, let's at least be honest about what the issue is. Now, the good news is when Jason was asked about the role NAR should play in this, he said they're a huge role. They're based on their size. They're the biggest trade group in America, which is a huge comment. The largest political contributor. They have been around for over 100 years. All of that is very important to understand, that there's a lot of political clout there. And he said, I think they can play a very constructive role going forward. I think their size demands that they do. It's the old saying, lead or get out of the way, and I hope they lead. Formed to be an anti-NAR group, it was to make them better. It was to make the industry better. I certainly hope that he is truthful on that. If that is the goal of AREA, then AREA can exist in conjunction with NAR and not as an opposition of NAR. Then that's great. Have 2 organizations, join the one that you want, join them both. That's fantastic. Hope that's the case. Now, on a different note with AREA, they did come out with a suggestion for a solution to clear cooperation. What they want is right now, when you put something in the multiple listing service, you have 24 hours to put it in the multiple listing service. It immediately gets put it in their syndicate service, which is like the IDX feed, and gets pushed out to Zillow, Realtor.com, Home.com, and all of those other websites. And what they want to do to resolve the situation, giving the consumer the privacy, is still requiring the consumer, still requiring the listing agent to enter the listing within 24 hours. However, allowing the consumer to opt out of the syndicate, meaning that it doesn't go through the IDX feed or similar feed system to Realtor.com, as well as going to Zillow and all of those. Now, their belief is that this would protect the smaller brokerages, because one of the big complaints that we've had when doing the show is that if we do go to this requirement of getting rid of clear cooperation, then the larger brokers can just hoard all of the listings, and then your clients can't see them unless you're a member of the brokerage, or you have to join the larger brokerage in order to sell real estate. This would allow the smaller brokers still to go on the MLS, find the properties and show the properties, but the house isn't getting advertised to the masses, to the public on Zillow and other websites. I haven't done a lot of research on that to see really how I feel about that. I think it's a good idea. It's something that should greatly be explored. The problem we've had in this industry recently is that people just want to have these knee-jerk reaction changes, and nobody wants to think about what the ramifications are, like getting rid of days on the market. What is the ramification for the consumer? Getting rid of clear cooperation. What's the ramification for the consumer? What's the ramification for the smaller brokerages, and so forth? So I like where AREA is going with this clear cooperation idea. I think it needs to be vetted on how it would affect the buyer, the seller, and the real estate agents, and see if that would be a good course to pursue. You also have to look at it and see how's that going to affect Zillow, Homes, and Realtors. Is going to violate any agreements they have. You know, here in Columbia, there's already mechanisms for this. You can list the property and sign an agreement to have it withheld from the MLS. The only thing is you cannot do any marketing and advertising of that property while it's being held from the MLS. This is allowing you to go ahead and sign with a client to provide them client services of advice, counsel, and advocacy. Perhaps you're trying to help get the house decluttered, get some repairs done, things of that nature before you're ready to start advertising the property. So we will see where that goes. They're calling it the public portal opt-in, not forced opt-out. And I think it's something we should certainly explore a little bit further. So that's kind of my update today on AREA. I think it is a viable coexistence to NAR. I do not think it's going to replace NAR. I do not think it's a threat to replace NAR. I think NAR is valuable, and it's necessary that they continue to lead. But if an organization wants to come and provide assistance, to provide background, to be a second voice, then all for it. I just want everybody to be honest in what we're trying to do here and not have an ulterior motive to get both sides of the deal or to try to get rid of small brokerages in favor of large brokerages. As long as we're not doing that, it's a great idea. All right, guys, y'all have a good weekend. I hope y'all will come back, like us, share, subscribe. And next week, we're going to try to get into agency. I think I've done some legal tips for the last 5 or 6 weeks on agency issues. I'm going to try to roll that into one concise podcast so that you'll have that for your reference in the future. All right, y'all have a great weekend. Come back and see us again next week.